to our webinar, Visa Options for Physicians. I am joined by my colleague, Naveen Bhora, in our New York office. My name is Jessica Marks, and I am in our Los Angeles area Santa Monica office. As you can see on your screen there, today we're primarily going to be discussing J-1 waivers for international medical graduates and paths to permanent residence for all international medical graduates, including those who have done their residency on H-1B or perhaps even in another visa status. So the first half of the webinar will be addressing those J-1 waiver options. So if you're not currently doing your residency or fellowship on a J-1 or haven't done so previously, then this may not apply to you, but may nonetheless be interesting for friends and families or colleagues. And then the second half of the webinar, we're going to be discussing two paths to permanent residence, primarily the Perm Labor Certification and the Physician National Interest Waiver. So there's our overview. As I said, the J-1 waiver option is going to be discussed for international medical graduates. There's 4 different types of waivers, one that we will only touch on briefly, and then 3 others that we'll get into in a bit more detail. We're also going to briefly touch on how to fulfill the terms of that waiver once you've been granted it. And then finally, the physician pathways to obtaining a green card. So Naveen, would you just like to go over briefly what it means to be subject to the 2-year home residence requirement and what it is?
Absolutely. Good afternoon, everyone. So the 2-year home residence requirement, we also refer to as Section 212E, basically says that you cannot get an H visa, an L visa, these are temporary work visas, or a green card until you've completed or complied with the terms of the 2-year residence requirement or obtained a waiver. This does mean that you can get all these other types of visa statuses, such as a J2, an O1, a TN. The other categories are listed below. The other sort of hiccup with the 2-year residence requirement is that you can't actually change your status within the U.S. If you do opt for one of these alternate visa classifications, you are required to go back to your home country, to the consulate, obtain a new visa stamp, and then return to the U.S. We often see situations where we've got physician couples, the principal's on a J1, the spouse is on a J2. As with the J2, you can get a temporary work card, which is an employment authorization document, and so sometimes the J2 spouse starts residency on that EAD, and then they decide to switch statuses, where the J1 finishes training, the J2 then switches to J1, and then the J1 has to switch to J2. In these situations, because they're both subject to the 2-year home residence requirement, they can't actually change status, and then within the U.S., they're both then required to go back home, get their respective visa stamps, and return. Another problem that has sort of come up recently is that the J2 spouses who are finishing residency with their EAD or just working in general, when the J1 principal goes for a waiver, which we'll discuss in greater detail later on, and has to switch to an H-1B, the J2 can file for a change of status to an H-4. However, after that, that J2 cannot then subsequently get an H-1 again. A possible solution may be to have that person go back home, get an H-1B visa stamp at the consulate, and then return.
Thanks, Naveen. Moving on about what to do if you are subject, and if you're listening to this and completing your residency or fellowship on a J1 sponsored through the Educational Commission for Foreign Medical Graduates, there's no question. You definitely are subject. So you have the option of fulfilling the requirement abroad, and you have to look at your DS 2019 to determine precisely what country that is. For most folks, that's not very confusing, but for some who have lived in several different places, had some permanent status in a country other than their country of birth or citizenship, it can get a little tricky. So if you're going to fulfill, you definitely want to make sure that you're going back to the right country, because it's not simply just being outside of the United States for 2 years. You have to go to your specific country of return as listed on your Form DS-2019. Or if you've been here for a very, very long time, maybe even your Form IAT-66. That's what it used to be back in the good old days. So as Naveen mentioned, you can also alternatively obtain another non-immigrant status to remain in the U.S. And the only non-immigrant statuses that you're precluding from holding if you're subject to the 2-year home residence requirement is the H or L status. So just to make sure that you understand, though, if that is the option that you pursue, that 2-year home residence requirement is still in effect. It does not go anywhere. So you're not going to be able to change status, you're not going to be able to get an H or an L, and you're not going to be able to apply for a green card even if you do get, for example, a TN or an O or an E3. And then, of course, your final option is applying for a waiver of the 2-year home residence requirement, which will allow you to change status in the U.S., allow you to apply for the green card, and allow you to get an H or an L. So if you decide to fulfill in your country of return instead of getting a waiver, again, I mentioned it has to be in a specific country, the country of nationality or last permanent residence. So before you get on that plane, make sure that you're going home to the right place. And a lot of individuals think that if they naturalize or even, into another country or even relinquish the citizenship of their country of return, then that somehow means that they're allowed to go to the new country instead of the old one. But that is not the case. There are sometimes situations in which if the person is able to show an inability to return to the appropriate country of return because they've relinquished that citizenship or, for other reasons, they may be able to get a waiver on those terms called impossibility of performance, but that's kind of been a gray area over the past couple of years. So if you are going to fulfill, then fulfilling in the country listed on your IAP 66 or DS 2019 is generally the way to go. That's going to be your safest bet. Now, this third bullet point here is kind of a hybrid between the first two bullet points on the previous slide, which is fulfilling but also obtaining a non-immigrant status. And that is because if you do obtain another non-immigrant status to remain in the U.S., you can still nonetheless fulfill the 2-year home residence requirement in increments, meaning that you can go back to your country of return 2 months here, 3 months there, 6 months here, and then accumulate that necessary 2-year period over an extended period of time. Now, something to keep in mind if that's what you're going to be doing is that the statute actually says physically present and resided in the country of nationality or country of last permanent residence. And so if you're subsequently applying for a green card or going to the consulate to pick up an H, after having done the 2 years, then you need to be prepared that to show that the time you spent in the home country was as a resident of that country. So what we oftentimes recommend to people is, have some bills in your name. If you own property, show that ownership of property, that you've received mail. If you've been working during the time that you spend abroad toward the 2 years, definitely get a letter of employment. All of that is relevant to showing that you were both physically present in and resided in the appropriate country of return. So Naveen, again, just touching briefly on what it means to postpone the home residence requirement by getting another status.
Sure. As Jessica was saying, you can do this in increments. So those who opt to stay on an O1 for a long time, it is possible to, for example, get a sabbatical and go home for a couple of months in the summer and eventually have an aggregate of 2 years that you can then document to show that you've complied with the 2-year home residence requirement. One other thing to keep in mind that this 212E, the 2-year home residence requirement, is there even if you're married to a U.S. citizen. you still need to comply with that requirement. I often hear that, I'm married to a U.S. citizen. Why can't I file for my green card? You can, but you must first obtain a waiver, either by fulfilling this 2-year home residence requirement by going home, or potentially getting a waiver through exceptional hardship or one of the other IGA waivers, which we'll go through in greater detail.
Yeah, the kind of way that I think about this, and I hope that I never offend anyone when I describe it this way, but when you enter the U.S. on a J-1 that is subject to the 2-year home residence requirement, you can think of it as becoming infected with a virus or a disease or something of that manner. And there is no cure whatsoever other than the waiver or fulfilling the 2 years abroad. Like Naveen said, marrying a U.S. citizen doesn't do it. It's just one of 2 cures to get rid of that infection.
Right. So now to just discuss what the waiver options are, we will go through all of these in a little bit more detail. To start with, the no objection letter is actually the most common waiver that is done, but it's actually not available for people who are coming for graduate medical education. It's generally the waiver of choice for people who become subject based on the State Department skills list, or if there was some form of government funding that triggered that 2-year home residence requirement. For IMGs, this is not an option, but if this is something that is available to you, then the way this is done is you actually first need to contact your local embassy in your home embassy in D.C. and find out from them what the process is. But basically, you initiate the process with the home embassy, and then it's sort of done between governments, between your home government and the U.S. State Department. And then once you receive the recommendation for that no objection waiver, then you will get an actual approval of that 2-year home residence, the I-612 approval from USCIS. Okay. The second form of waivers is a persecution waiver, and this one you do actually need to document actual fear of going back to your home country. This isn't just a situation where there's a deteriorating country conditions in your home country and you're afraid to go back. There does need to be some form of documented, a fear that you would have as an individual, something directly that may have happened to you in the past or to your family that would indicate that you would be singled out as opposed to anybody else who's just going back to a deteriorating country condition situation. Once you can get this persecution waiver, it is just a waiver of that 2-year residence requirement, and then you would need to obtain the appropriate non-immigrant visa, such as an H-1B, and then possibly apply for asylum, because the 2 types of cases are very similar, getting the persecution waiver and then sort of transitioning on to an asylum application, which is a green card process.
So moving on to the third type of waiver, this is more along the lines of what Naveen was saying the persecution waiver is not, and that is establishing exceptional hardship if you are to return to your home country for the 2-year period, and deteriorating country conditions can be a relevant consideration. But you must have what is called a qualifying relative, which means either a U.S. citizen or a lawful permanent resident, which means green card, spouse or child. And you have to establish that the hardship would be to that qualifying relative, not necessarily to you. Although, if you go home for the 2 years and will experience some hardship yourself, that may be relevant to the analysis if you can establish that that will result in some kind of indirect hardship to the qualifying relative. So this is actually a 2-pronged test, and you must show that the citizen or green card holding spouse and or child will experience exceptional hardship both in the event that they remain in the U.S. without you and you go home for 2 years, and then also in the alternative scenario where they accompany you to the home country. So you have to meet the burden of proof on both prongs, because if the evidence just establishes that the spouse and or child would experience hardship in one of those situations, then U.S. Citizenship and Immigration Services is going to determine that you've not established your eligibility for the hardship waiver. So this waiver can be filed at any time during residency or fellowship. The interested government agency hardship waivers that Naveen's going to discuss next are tied to the fiscal year. So you can only be granted the waiver between October 1st and then September 30th of the fiscal year. But this can be filed at any time. Now that said, with the caveat that you don't want to apply too early in your program, because Department of State about a year ago now started taking the position that if you extend your program after getting the waiver, then they may consider you resubjected to the 2-year home residence requirement. That's not necessarily a legal point with which we agree, but the timing does need to be taken into consideration so that you don't have any problems down the line when you're trying to apply for a green card or an H or an L. So if the waiver is granted and you have a basis for permanent residence, you can immediately apply. So if you're filing your hardship waiver based on exceptional hardship to a U.S. citizen spouse, you get the waiver. That spouse can then immediately sponsor you for an immediate relative petition, and you can concurrently file for the green card. If the application is not successful, that does not prejudice you against applying for any type of other waiver in the future, including an IGA, interested government agency. So there's really no harm in applying for an exceptional hardship waiver other than time and resources and money that you expend in the process. So this waiver does not, and really no waiver, provides the physician or applicant with any kind of underlying non-immigrant status. So once you get the waiver, you're still on your J1. And if you don't have an option for applying for permanent residence after getting the waiver, then an H-1B or other non-immigrant visa must be obtained in order to remain in the U.S. And one thing that I'll say in regards to going from a J1, getting a hardship waiver, and then another non-immigrant status is that you're actually not able to change status in the U.S. The J1 waiver that allows the applicant to change status within the U.S. as opposed to consular processing abroad is exclusively the IGA waiver for physicians. And that may seem unfair. I've established exceptional hardship. Why should I have to go back to my home country and apply for this visa now? But that's just the language of the regulations. And while some people have successfully kind of slipped through and changed status from J to another non-immigrant after getting a hardship waiver, it's technically not permitted by the regulations. So Naveen now is going to take us through a few different types of interested government agency waivers.
Thank you, Jessica. I also want to point out that both with the persecution waiver and the exceptional hardship waiver, the petition is initially filed with USCIS. They first review it, and if they're okay with it, they approve it, then it goes to the State Department. When you are dealing with an IGA waiver, the application is first submitted to the government agency that will support the waiver application, and if they are okay with it, then they forward it on to the State Department, who then rubber stamps it if they're okay with it, and then it goes to USCIS. So with IGA waivers, you're actually dealing with 3 different government agencies. One other point is that when the petition goes to the State Department, oftentimes the State Department may make a policy decision not to support a waiver application. We have had situations where a physician was granted an exceptional hardship waiver because of hardship to U.S. citizen children, but the State Department did not support immigration's finding of exceptional hardship for policy reasons, denied the waiver application. The physician then got an IGA waiver, and then the State Department found that to be acceptable and then did support the IGA waiver application for that particular physician. So in some ways, the State Department is more likely to approve a waiver application if it's coming through an IGA, such as one of the Conrad 30 waivers or the VA. Now going through these, before I go through the Conrad waivers and the VA waivers, I did want to mention the Delta Regional Authority and the Appalachian Regional Commission. These are actually very helpful, especially for states where the Conrad waiver numbers go through really quickly. Just to mention, for the Appalachian region, the states are Alabama, Georgia, Kentucky, Maryland, Mississippi, parts of New York, North Carolina, Ohio, Pennsylvania, South Carolina, Tennessee, Virginia, and West Virginia. For the Delta Regional, that is Alabama, Arkansas, Illinois, Kentucky, Mississippi, Missouri, Louisiana, and Tennessee. The employer not only has to be located within these regions, but they must also be located for the DRA within a HPSA in these locations, or an MUA or an MUP. For the ARC waivers, they must be located in a HPSA area within these Appalachian regions.
Can you mention what those acronyms are, Naveen?
Oh, so sorry, the ARC is the Appalachia region?
No. I meant HPSA and MUA and MUP for folks who might not be familiar with those terms.
The HPSA is the healthcare physician shortage area, and that is designated by the Health Resource Service Administration. So when you are actually looking at potential job opportunities and weighing your options, you can actually go to the HRSA's website and plug in the address for the potential job site to see if it is within a HPSA or a medically underserved area. So that is actually very easy to find. Okay, now for just a little bit more detail about the IGAs, any federal agency can serve as an IGA, but the ones that we actually end up using are the most common are the state Conrad program, which is the state Department of Health. The VA is also another common IGA-based waiver. Okay, now all states have a Conrad 30 program, and every state has a different way of administering the program. So when you are looking at job opportunities, you do need to find out what the rules are and when you need to start applying for one of these particular waivers, especially in a state that's very popular, such as California or New York. The 30 slots do get taken up pretty quickly, and as Jessica had mentioned, it is based on fiscal year. The idea would be that if this is your last year of fellowship or residency and you are thinking about what you're going to be doing following graduation, you would start the summer before. So start looking for jobs around July, August, have a contract secured by August so that the waiver application can be started by the early fall and have everything ready for filing by October 1. Most states do have the application period start October 1, but some states, such as Texas, has a different timing. It is on a first-come, first-served basis. Some states will wait till they receive a certain number and then sort of go through those and decide which ones are the most desirable or favorable for their state. There are other states that don't get numbers used up, and if it's the winter or the spring before graduation, there are still a lot of states where there are slots available. I just recently did one for West Virginia and South Carolina in the spring. Those went through pretty quickly, but again, some states have a requirement that the facility needs to be registered with the state. So that's just another requirement that needs to be met. But once a facility has been pre-cleared, the actual physician's waiver application goes through pretty quickly. Most states do require that the job is in either a HPSA or an MUA, but there are some flexibilities, these 10 flex slots, where the actual hospital or facility is not located within a HPSA, but the patient population is coming from an HPSA. So it is totally possible to get a Conrad waiver, for a hospital in Manhattan, as long as you can show that that the patient population is coming from an underserved area. And also, these aren't necessarily rural sites. There are HPSAs and MUAs within urban areas as well. Manhattan has certain blocks that are considered MUAs. We've done a lot of waivers for, for people working in Chicago, for example, as well.
So as Naveen mentioned, the application is submitted directly to the State Department of Health, and a lot of them have their guidelines published on their websites, or at least a contact person who you can get in touch with and request a copy of their application requirements. They can vary significantly between the different states. So it's really important to know exactly what you have to submit with your application package, and particularly for those states that fill up very quickly, Texas, Florida, New York, you want to make sure that you have everything in your initial filing so that you don't miss out on a slot because of some technicality or missing document or piece of information. Most of the individuals who administer these programs are very knowledgeable. They're very friendly and very helpful, so you can always feel free to reach out to we call them the State 30 contact. Some of these states do have rather significant filing fees. Ohio and Texas are given there as examples, $3,571, $2,500. So that is something for any employers listening to think about in budget and deciding how much they are going to kind of allocate to the recruitment of an IMG, and what expenses are going to be associated with the employer paying and what the physician may be required to pay. When it comes to what type of medical practice or specialty the physician will be engaging in the underserved area, there is a pretty, I would say, substantial number of states that have a preference for primary care physicians over specialists. And primary care is OBGYN, psychiatry, internal medicine / family practice. There's a very specific definition, and then anything beyond that is considered a specialist. And one note that we'll put up there is that there are some physicians who have fellowship specialist training, and that comes after their family practice or internal medicine residency, and then are sponsored for a internist or perhaps a hospitalist position in their waiver. And some states really don't like that, or they won't even accept the application because their assumption is that you went through all of those years of subspecialty training, you're going to want to use it. And so even though the application may be for an internist or family practice physician, they think that you're really going to, at least part of the time, be involved in the practice of your subspecialty. So that goes to what are you actually agreeing to do if you engage in one of these waiver applications and engage in agreement with an employer in an underserved area that's going to be sponsoring you. So you are committing to at least 3 years of service and 40 hours per week of service at that underserved location. And that does not include on-call time. It doesn't include travel time. It just includes the provision of medical care to the patient. So there are certain contract requirements not only for the states but for the U.S. Department of State as well, which, as Naveen mentioned, is the second agency that will be looking at your waiver. So once the contract is finalized, there really needs to be a close cross-checking of the individual states' requirements and then also the Department of State. You can see there on the screen that some states do not allow non-compete clauses. So that's one example of a restriction that a state may have in its particular State 30 policy. Some states do require more than 3 years, so that's something else to know before your contract is finalized and when you're selecting your state, because you want to make sure that you are somewhere that you're going to want to be for that entire period. And if you have family members, especially a spouse, that you're in an area where they're going to be happy as well. The recruitment requirements also vary from state to state. Many of them require at least 6 months evidence of recruitment to establish that no U.S. physician could be found to work in the position that's being offered to you. So that's just one more piece of evidence that you're going to have to double check the state's requirements. And if you are speaking to an employer far in advance of when your application would be filed, if they haven't started that recruitment already, then they may want to do so based on that given state's requirement. Looking forward after you get the waiver, one very nice thing about doing a Conrad 30 is that your change of status from J1 to H1B is exempt from the annual fiscal year cap. There is a cap of $65,000 and then an additional $20,000 for graduates of U.S. programs, at least a master's or higher. So that's a cap of $85,000. You don't have to worry about whether you're going to be allocated one of those numbers, whether there's an H-1B visa lottery. You're not going to be restricted to an October 1st start date. None of that applies to you, so don't worry about it. And like I said earlier, getting the Conrad waiver also allows you to change status within the U.S. from J to H-1B, so that's another added bonus. In regards to the moonlighting, if you are on your H-1B and you are completing your 3 years of service, you can get a concurrent H-1B petition to moonlight with another employer. Do that on a part-time basis as long as you're still doing your 40 hours a week at the location in your waiver application for your primary employer. And this is fine by USCIS. But the State Department of Health that sponsors your waiver may or may not be okay with moonlighting. So that's one thing that you'd want to check with them first. Technically, what they like or prefer or what they think in that regard shouldn't really matter, because if it's permitted by USCIS to have part-time employment, then the state shouldn't really have any say. But that state is going to be watching over you for at least 3 years, so it's advisable to have an open line of communication with the State 30 contact and to keep him or her pretty happy. When you're on the H-1B, you must be an employee, and that means receiving a W-2, and cannot be a 1099 independent contractor. That 3 years of service, as I mentioned, has to be fulfilled at the location on the waiver application. It's oftentimes listed in the Waiver Review Division Department of State letter, and then also on the final approval notice from USCIS. And if you disclose in your initial application that there's going to be other locations on top of that primary underserved location, that's generally not problematic. But if subsequently you're going to be adding on new locations, then that can become a little bit trickier. Again, the state shouldn't really care as long as you're still doing the 40 hours a week at the location on the waiver, but it's always good to keep them apprised of new locations, so in case that there's a site visit or something of that nature, they show up at your primary location, you're not there, at least they'll have already been informed why that may be. In regards to changing waiver employers or locations during the 3-year period, it is strictly not permitted unless you can demonstrate extenuating circumstances. And the somewhat frustrating thing about that standard is that it is not defined in the regulations, the immigration regulations. They do give an example of a facility closure, but other than that, it's a pretty flexible, open-ended standard. And the H-1B transfer petition that's filed by the new waiver employer has to be documenting what those extenuating circumstances are. If you're going to be moving states, then getting a letter from state number 1 and state number 2 saying that they support the extenuating circumstances transfer is not actually required, but it can be very useful in getting that H-1B transfer approved. Naveen, what have been some successful extenuating circumstances transfers that you've seen?
Well, one that was successful was where there was a newlywed couple, and they were one was doing residency in LA, and the principal J1 Conrad H-1B position was about a 3-hour drive away, and immigration bought the argument that he needed to change employers so that they, as a newlywed couple, could be together. I've had another situation where the physician had unreasonable work schedule or call schedule with his Conrad waiver employer and wanted to switch jobs, and that was not supported as an extenuating circumstance.
Yeah, so it's a really kind of hit or miss, and it's a little difficult to predict the outcome of an extenuating circumstances transfer, again, just because that standard is so loosely defined or really not defined at all in the regulations. So if that's something that you're thinking of doing, you need to put quite a bit of careful thought into it, because those two examples that Naveen has given, something that you would think would maybe not be such a compelling argument, those cases sometimes go through without a problem. Other times, something that really does seem like an extenuating circumstance and is supported by really solid facts, immigration may decide that that does not rise to the necessary level of an extenuating circumstance.
Thank you, Jessica. Now, the VA is another IGA that will support a J1 waiver application. The VA is its own organization with its own policies on how they administer the J1 waiver program. There is no HIPAA or MUA requirement. Having a job at a VA is sufficient. However, the VA does have its own policies. The VA does require there to be extensive recruitment for a U.S. Worker before they'll support the waiver application. The one benefit of having a VA waiver is that it is open to specialists. It's not just limited to primary care, and so that is an attractive option for physicians to go into specialties. However, just a warning, because the VA has their own policies on how they administer things that are not required by USCIS or Department of Labor regulations, it does add levels of complexity, such as when you're applying for an H-1B visa for a VA position, the VA will advertise. That's not required by CIS or the Department of Labor. We've heard stories of where the physician was doing a waiver through the VA, needed to complete those 3 years on H-1B status, had to file an extension to complete that 3-year obligation. And for that extension application, the VA did some recruitment, found another available U.S. worker, and decided not to support the H-1B extension for the physician. And so the physician basically lost, those few years trying to fulfill that waiver obligation, and then was sort of not successful in finishing it up through the VA. We often see physicians who have academic appointments at universities with a dual appointment of the VA, for example, with UCLA and the VA in West LA, or University of Pennsylvania and the VA in Philadelphia. This is fine. Often the physicians come in on O1 status, but the VA is pretty strict that they will not start a waiver process for the physician been on O1 status until they've been there for at least 2 years. So that's just something to keep in mind, that the VA does have its own policies on how they'll administer this program. Another issue to keep in mind is that if you decide to stay with the VA and you're there for 2 years on O1 status and then completing your waiver obligation there into 3 years, that this may then transition and give you the 5 years that you'll need to get a green card through a national interest waiver. And Jessica will go into that in further detail.
So moving on to the last IGA that we are going to discuss, the U.S. Department of Health and Human Services. They have two programs, actually. One is for clinical care, and then the other is for academic researchers who are performing research in an area of priority or significant interest to the HHS Health and Human Services. So if you are going to be doing an underserved waiver, you can do it through the first program. If you are a researcher, physician, scientist who has found his or her way into academia, then the second program may be an option for you. If you're going to do the clinical waiver program, then you do have to be working in a HPSA, and the score of that HPSA has to be at least 7. Rural or urban, just like the Conrad State 30, will qualify. And then you must obtain an acknowledgement from the State Department of Health. So you're still going through that agency as well. The application is filed directly with the HHS, which generally processes them very quickly. As long as you meet their very exacting standards, it usually takes at most a month for the waiver to be approved and sent on to the U.S. Department of State Waiver Review Division. The current position of the HHS is that the physician must commence work within 1 year of completing the residency. So again, this is another one of those timing issues where it's not even just that you have to submit the application within a certain period of time, but you actually have to start work within that 1 year. If you're getting toward the end of that 1 year and the waiver has still not been adjudicated, then that HHS clinical program may disappear for you as an option. They only accept primary care physicians and psychiatrists, no subspecialists, and the same commitment is 3 years and 40 hours a week, and they do also require recruitment. For the research waiver, there is no contract requirement, but the position does have to be permanent in nature. So if you're a professor, tenured or tenured track, again, there has to be recruitment, cannot be more than 18 months old, and it usually has to take the form of an advertisement in a national journal. So, you know, for example, if it's for someone in the field of gastroenterology, then gastroenterology would be an appropriate journal, assuming that they have advertisements, which I'm assuming that they do, having not looked at that journal too recently. The primary elements that have to be established in order to establish eligibility for this program, the research in which they're engaged has to be of a national priority and interest to HHS. So that means that if you're only engaged in research projects that are funded by your academic institution or state organizations, smaller professional associations, that's probably not going to do the trick. It has to be at least some federal funding, and obviously the larger the amount, the longer the period over which the funding has been guaranteed. All of that is going to enhance the likelihood of success on that waiver application. The researcher must also be essential to the research program, to the grants that are being conducted. And generally, that means a very high burden of proof to the extent that the HHS wants to be assured that if you do not get a waiver, if you were to be required to go home to your home country for at least 2 years, that the success of that research project would be so severely compromised that it may become a completely non-functional program. Essentially, there has to be no one else that can replace you. You're not just duplicating the efforts of someone else on that grant. You're the only person who's bringing a unique background or skills, and your removal from that grant would essentially result in it no longer being able to move forward with that funding. Again, there is that evidence of recruitment, and the employer, in submitting the application to HHS, must establish that no replacement can be found. So let's take a look here at what kind of time frame we're looking at when you're applying with an IGA. Naveen, can you walk us through that?
Sure. So generally, there are these three different agencies that are involved. The first part of it would be either the State Department of Health, the ARC, the VA, or the DRA. This can really vary. Conrad waivers can go through the state fairly quickly, or states that decide to collect as many, applications that they receive over a certain period and then only adjudicate after 90 days. Those will take longer. There are states such as, they will collect these, start receiving the applications in October, and then only decide in January, February as to who they're going to select for their 30 slots. The VA, as you can see, can take much longer than the other IGA waivers. Once the State Department receives the IGA's recommended petitions, the State Department can take another few weeks to look it over and then give their approval and recommendation to USCIS. Once USCIS receives the State Department's letter, then at that point you can actually file the H-1B petition with CIS, and then CIS will adjudicate both the H-1B with the 612 waiver application. Generally speaking, an H-1B at CIS can take a few months, but there is possibility of doing premium processing so that the actual final H-1B can come through within 2 weeks.
One thing I want to mention, the reason that Naveen and I keep talking about an H-1B is that the statute, the Immigration and Nationality Act, actually doesn't touch on what status those 3 years must be done in, but there is a regulation that provides that a physician can complete the 3 years of service only in H-1B status. So that's why we keep talking about that as opposed to an O-1, for example.
Right. So if you are at the VA on an O-1, or you're working at a hospital on an O-1, and then you receive the actual J-1 waiver, you do need to file for a change of status. Even though it's the same employer, same job, you do need to switch to an H-1B status, and the clock at that point starts with your 3-year commitment. One final point on the J-1 waivers, and then we're going to move on to green cards, is that there can only be one waiver application that's granted. That you can file two. You can have that persecution or the hardship waiver done, but only one will actually be supported by the State Department, and it's whichever one is adjudicated first. Okay. All right. Now for the green card. The green card is the final sort of step in this process. The idea is that you are getting your J-1 waiver taken care of, and while you are fulfilling that 3-year requirement H-1B status, you can start the green card process as well. This can be particularly critical for people who are in preference categories, which we'll go into in a little bit greater detail, that are backlogged. So that if you are, historically, if you're married to a permanent resident, for example, that category was backlogged, and the idea would be to have the immigrant petition filed and getting a priority date locked in, so that by the time you finish your 3-year commitment, you are eligible to file for adjustment of status, and your priority date can become current. This is also true for people who are going to go through the perm labor certification process, that process can take over a year to complete, or if you are from a backlogged country such as India or China, the idea would be to start the process as early as possible to lock in an early priority date so that you don't have to wait as long once you've finished your 3-year obligation. And even though you have an approved immigrant petition, such as an I-130 for family-based or an I-140 for employment-based, you do need to have that 3-year of H-1B time completed before you're eligible to apply for the adjustment of status, which is the final application process in the green card process. Okay, now we're going to go into a little bit more detail about the perm labor certification and the national interest waiver for physicians. This is just a comparison of the two different processes, and I will go into a little bit more detail about perm, and Jessica will discuss the NIWs, but this does give you an idea of some pros and cons of going through one or the other. My personal preference is the perm. If you are happy with your employer where you're doing your waiver application, then it's a great option to start the perm process as early as possible, and so that as soon as the H-1B 3-year commitment is done, you'll have had your perm and your immigrant petition approved, and you just file for the adjustment of status and you're done. Whereas the NIW, would be a 5-year commitment, but there is a little bit more flexibility in that you're not, you're not dependent on an employer sponsorship. You could do the sponsorship on your own. Okay, now for the perm labor certification, this does require an employer to actually offer you a position and go through the requirements of testing the labor market and offering a position once you have been admitted as a permanent resident. It's very critical to keep in mind that this is a future job that we are testing the labor market for, that there is a intent to hire you as an employee for this position once you're admitted to the United States as a permanent resident. The employer must offer to pay the prevailing wage, and so the first part of this perm process is to obtain a prevailing wage determination from the Department of Labor. The Department of Labor will go through their own data on what the wage is for a particular occupation in a particular area. For the physician categories, they don't actually have that much data, and so they often will assign a fallback of $90 per hour for most physician specialty occupations. Okay, the perm process takes about 10 months, and that the actual part of testing the labor market would take about 4 months, and then the employer can show that they don't have any available U.S. workers for the position, and then the petition is filed with Department of Labor, which can then take another 6 months to adjudicate the case. It is an online submission, and only in the case of an audit will the employer actually need to provide all of their evidence of recruitment and any resumes that were received during that recruitment period. For the underserved areas, this is actually pretty easy to do because they've, often have already gone through the recruitment process in trying to find a physician for their facility, and so we can sometimes use some of the advertisement that was already done, but the ads cannot be stale. They must be within 6 months of filing. So we would often ask the facility to re-recruit, and they also need to do certain additional specific recruitment steps that are mandated by the Department of Labor. Okay, the recruitments are, there is a 30-day job order that has to be submitted to the state. There are 2 Sunday ads in a local newspaper. And we all know that physicians aren't looking for jobs in the local newspaper, but this is a Department of Labor requirement. The employer needs to also post in the place of employment So this means that even though you're being hired by a particular private practice group, if the services are being rendered in 3 different hospitals, then the posting actually needs to be done in all the facilities where the physician will be working. And because these are professional jobs, there has to be 3 more additional forms of recruitment. The common ones for the 3 additional forms of recruitment are often the employer has to post on their website. They can do another print ad in a local newspaper. We've done radio ads. If they already have a recruiter that's been engaged, then you can do another posting through the recruiter, or you could use a job search engine such as Career Builders or Monster.com and post another ad as your 3rd form of recruitment. Once the labor certification is approved by the Department of Labor, then the employer has to file an immigrant petition, which is a Form I-140 with USCIS. And at that point, the employer has to show that they've got the ability to pay the prevailing wage proffered salary. This can often become an issue for smaller practice groups because you are expected to submit your tax returns or an audited financial statement, and the net revenue that's reported on the tax returns has to exceed the proffered salary for the employee physician. And with the smaller groups, they often show losses, and this can become an issue with ability to pay. There are ways that you can tackle this. If the person's already on payroll working for this employer being paid that wage, then USCIS may take that into consideration, even though the employer is reporting a loss on their tax returns. The other thing is that the proffered wage that is stated on the labor certification doesn't actually need to be paid until the person is actually working there in permanent resident status. Okay. Lastly, we often hear that a resident or someone who's finishing their fellowship has a job offer, but they're not finishing their training for another 6 months, so they want to start the perm process with their future employer. This is all great. It's great to be proactive. However, the applicant must make sure that he or she has met all the requirements for the job at the time the labor certification is filed. So ideal situation would be that we would start the perm process maybe in the spring, 3 or 4 months before the person finishes training, so that the recruitment and testing the labor market is completed, and just about the time when the applicant has finished their credentialing, has finished their fellowship requirements, then we can file the perm labor certification so that the applicant can show that the applicant has met all of the requirements for the job at the time the application was filed. All right. Now, once the perm labor certification is approved, it is only valid for 6 months, and so the employer must file the immigrant petition with USCIS within the validity period of the approved labor certification, and then once the immigrant petition is approved, then the last stage would be to file the adjustment of status application. But for J1 subject physicians, that can only be done once the 3-year time commitment has been met. It is possible to have the green card process filed by an employer that's separate from the current H-1B employer. So it is possible to do your J-1 waiver, H-1B commitment with employer A, and have a permanent residence process started with employer B. That's totally fine. And then also for people who are running out of H-1B time because they've had started their H-1B process were not on a J-1 but was doing all of their residency in H-1B, they may be running out of H-1B time because there is only a 6-year limit to H-1B. But if you had started this green card process, the labor certification, before your 6th year begins, it is possible to get 7th or 8th year extensions beyond the 6-year limit. If the I-140 petition has been approved, then it's possible to get a 3-year extension of your H-1B time beyond that 6-year limit if you are from a country that's considered backlog, such as India or China.
And kind of getting a visualization here of what it means for there to be a backlog. What you see on your screen right now is the U.S. Department of State Visa Bulletin, and this is the employment-based preference categories. As you can see, there are 5 different preference categories, and those dates there represent a cutoff point. Because there is only a limited number of immigrant visas, and when we talk about immigrant visas, that's kind of just another word for the green card, there's a limited number available each fiscal year. And when the demand for the visas exceeds the supply, and there is a per-country limit, there are cutoff dates established, and you'll see that they have them for different categories and different countries because in particularly those last 4 countries, the demand for people born in those countries exceeds the supply so severely because of that per country limit that some of the backlogs go back to, you can see, almost 10 years. So the confusing thing about the Visa Bulletin is that it comes out every month, but that does not mean that the cutoff point advances every month, because there is a single brilliant human being in charge of this thing at the Department of State. He is a statistician, and his goal is to make sure that all of the available visas are used each fiscal year because they don't carry over to the next fiscal year, but at the same time making sure that demand is not so excessive that the cutoff date just keeps going back further and further. So he has a really tough job, and I do not envy him at all. And while we do have some pretty significant backlogs in some areas, we have seen recently some pretty significant forward movement, and that's usually what we see around this time of year because September 30th is going to be the end of the fiscal year. So the State Department is moving those dates forward to the extent possible to generate demand and make sure that all of the available numbers are used before the fiscal year ends. So if you want to have a better sense of what do these dates mean to you, if you're an IMG, you're going to be in the second preference category, and that's whether you are sponsored through the Perm Labor Certification or through the NIW. So if you are a physician born in India, you would have needed to have a Perm or an NIW filed before June 15th, 2008 in order to be eligible for a green card right now. So that's how you read this Visa Bulletin. That's why it's important, as Naveen mentioned, for individuals born in certain countries to get the green card process started as quickly as possible. Moving on to the NIW as an option for pursuing lawful permanent residence, I'll go through this quickly because Naveen touched on some of this already. It is a self-petition. You do not need to be sponsored by an employer, but you do need to have a 5-year contract as opposed to a 3-year contract, and at the time that you file the NIW, that contract can't be more than 6 months old. So if you're just going to try and tack on 2 years to your 3-year contract, it's pretty easy to make sure that you have a proper date on there. Just with the IGA waiver, you also have to go to a state health department or a VA to get a letter from them, and that letter can also not be more than 6 months old at the time you file the NIW. Unlike if you're being sponsored for a perm and you have that 3-year service period, you can file the I-485 for lawful permanent residence during your 5-year commitment, and even if you're still in the 3-year commitment, but it will not be approved until that 5-year period is over and you have submitted evidence confirming that you provided those 5 years of service. There is no requirement to establish that there's no U.S. workers. There's no salary minimum. It's solely based on providing services to patients in a HIPSA, MUA, MUP, or a VA. If the area loses its designation after your employment begins, that's not a problem. You can still receive your green card based on that NIW, provided that it did have that designation when you started work. The 5 years can be done in any status other than J1. So for example, if you did 3 years of residency and a 2-year fellowship on an H-1B, and that was all done in underserved areas, then that could be your NIW right there, and you can file based on exclusively based on time that has already been served. It does not have to be on prospective time. It can be a combination of past, present, future. It's really flexible in terms of when the 5 years of service was provided in the underserved area. We want to just briefly touch on some legislative updates. Pretty much unless you've been living under a rock, you would know that there is a lot of talk about comprehensive immigration reform, and there has been some forward movement. We're at a period right now where that forward movement is a bit stalled because we are in the August recess for Congress. But looking at what has happened over on the Senate side, we have S-744, which is the Border Security, Economic Opportunity, and Immigration Modernization Act. And it has several important provisions that affect IMGs. I've listed a few of them there. The NIW exempts you from those numerical limitations on immigrant visas, and that's also true for your dependents. If you're finishing the 3-year J-1 waiver commitment, you would move up into the EB-1 category when you're applying for permanent residence, and there is no backlog in EB-1. So especially for the Chinese and Indian-born physicians out there, that's very important. It also loosens the restrictions and gives a bit more certainty in the extenuating circumstances transfer situation. If you're unable to document extenuating circumstances, then you can nonetheless transfer, provided that you are willing to do a 4th year of service on top of the 3-year commitment you already had. You just do 1 more year. There's a cap gap protection. Most of you in doing your residencies and fellowships will have a DS 2019 that expires on June 30th. So if you don't have a start date on your H-1B petition during your 30-day grace period, then you have to leave the country generally. But this provides for not only an extension of your status until October 1st, but also work authorization through that period, which you would otherwise not have because you don't have your J and your H-1B hasn't taken it into effect yet. You just need an H-1B pending in order to get that extended work authorization. Really big deal for the J-2s. You would no longer be subject to the 2-year home residence requirement, and that would completely eliminate the problem that Naveen was talking about at the very beginning, where CIS is currently taking the position that J-2s cannot change to H-1B while the J-1 principal is completing the 3 years. That's completely unsupported by the regulations, not supported by the Immigration and Nationality Act, but that is the position that U.S. Citizenship and Immigration Services has currently taken, and this legislation would remove that problem in its entirety. Looking over to the House of Representatives side, there is a Conrad State 30 and Physician Access Act. This has a really nice elevator provision for increasing waiver slots. And I won't go into all the math here, but there is, as we said, a lot of states that have traditionally filled up sometimes on the first day very quickly, and then other states that in the past year or so that never used to fill up are filling up before the end of the fiscal year, sometimes even just halfway through, and that is making those numbers that much more in high demand and, creating competition to get your waiver filed as quickly as possible. This would essentially maybe not eliminate the problem in its entirety, but do a lot to address it, because the numbers can just keep increasing provided that a certain percentage of waivers available to certain states were used in the previous fiscal year. And as I said, I won't go into all the math, but there it is up on the screen, and you can pull up the text of the Conrad State 30 and Physician Access Act online if you want to learn more about what it would mean for your situation. So we have our information here up on the screen. There is a monthly newsletter that we send that makes announcements about all of these issues. We do offer an initial free consultation, so you can fill out the questionnaire there, or you can simply get in touch with Naveen or me. We had our email addresses up on the first slide, and these slides will be available online after we're done. So feel free to get in touch with us, and we can answer any questions that anyone has now if you want to type them up on the screen. Okay, it looks like we don't have any questions for the time being. So if you want, oh, sorry, I spoke too soon. Here comes one. My question is, are you eligible to apply for a physician J1 visa stamp without fulfilling a prior J1 research 2-year home rule? And the answer to that question is yes. If you are subject to the 2-year home residence requirement because you came under the sponsorship of ECFMG, that does not preclude you from getting a J1 that would also be subject and based on research and vice versa. Someone is asking if there's a way to get a copy of the presentation. Yes, it will be available online.
I just wanted to add to that earlier question. If you are going from a J1 research to J1 clinical, a GME, ECFMG will ask for some kind of a nexus between the research and the clinical training. So there does need to be an explanation provided as to how your hopes of receiving clinical training will further your interest and the research that you had previously done.
And so our next question is, can a J1 holder apply for a green card through the EB1A or EB1B category after obtaining a waiver of the 2-year home residency requirement? And there is actually no restriction of filing that EB1A or EB1B. The immigrant visa petition itself can be filed. It's just that last step of filing the I-485 green card that cannot be done until you receive the waiver. And if you do an IGA waiver with a 3-year requirement, not until after that 3-year period has been completed. So the answer to the question is yes, you can do the EB1A or EB1B, but if you are subject, there is no filing the I-485 until after you've received the waiver. So I think that we are unfortunately just out of time now. It is 1:45. So apologies to anyone whose questions we did not reach, but feel free to reach out to us offline. As I mentioned, we do offer a free initial consultation. And Naveen, thank you for joining me today, and thank you to all of our listeners.
Thank you.